So, as Tony mentioned, I'm going to talk about preparing a corporate representative for the reptile theory defense. Reptile theory is a litigation tactic, I know most of us have heard about it, in which plaintiffs try to pursue a particular strategy in which they claim to seek to trigger the reptile brain of the jurors, thereby having the jurors believe that they are in some type of danger, therefore seeking safety. Safety equals big verdicts. At least that's the theory. And that theory has gained some traction. There's been a lot of success by some plaintiffs' counsel in using that theory. And the reason I believe that there has been some success is because we, as defense counsel, have not adequately evolved in handling these types of cases. We're trying to use some of the things, or the things that we've used for years and years, the tried and true formulas that we've used to have success. And when plaintiffs are using these new techniques, and I'll go through exactly kind of how they're doing it, it's difficult when we're using the traditional tactics that we use. So reptile theory in general, they're trying to stimulate, at least this is a theory, certain instinctive responses to fear or danger. That's the reptile brain. The theory is that when the reptile goes into survival mode, it will seek safety. Again, safety equals big damages. That's the theory. Now, in order to figure out how to deal with the reptile theory, particularly at corporate rep depositions, we have to understand it a little bit. Now, I'm no psychologist, but I do have a daughter who is a sophomore and she's a psych major at Pitt, and I pay them tens of thousands of dollars. So whether I'm qualified or not, I'm going to talk a little bit about the psychology of the reptile theory. Reptile theory is based upon the theory that the jury will act instinctively when faced with fear or danger. But a number of commentators have shown, I think pretty convincingly, that there really is no such thing as the reptile brain being triggered in a jury situation. By example, there are three types of processing that the brain uses. There's high road cognitive processing. That's a situation where if you hear that there's a lot of crime, new crimes happening in your neighborhood, well, maybe you decide to put on a new door lock, make sure the windows are locked, maybe buy a gun, do different things, but it's an executive function decision-making, and you're weighing the pluses and the minuses, and you're coming up with solutions. Then you have the low-road cognitive processing. That's a situation where you're in your bed at night, and you hear somebody break in through the door. Now you're making quick decisions. You're deciding run, stay, and fight. Those are still executive functions because you're making decisions. Then, of course, the third is the startle response. You're sitting in the library, someone sneaks up behind you, screams, "Hey," you jump. There's no thinking. That's just instinctive. Now, you can never, and commentators state, you can never get a jury to low-road cognitive processing or to startle response because a jury is never really in fear or in danger. It just doesn't happen. What the jury is really doing is responding to what the plaintiff is doing, which is trying to misdirect the focus away from the legal standard, away from the lack of damages, onto the specific conduct of the defendant. Whether that conduct is reasonable or not, is trying to show that that conduct is what ultimately causes the injury. The jury is always going to rely, notwithstanding the theory of this reptile brain, is always going to rely on reasoning and logic and common sense. And we're going to be in big trouble if the jury ever stops relying on these three things. That said, the reptile theory has had great success. And the reason it's had great success is because the plaintiffs have evolved their tactics so that they're trying to take the focus off of damages, off of the legal standard, and onto what they refer to as safety rules. The formula, this is the core formula for reptile theory. Safety rules plus danger equal reptile theory. When it gets down to its bare base, it's really just trying to shift the focus of the jury. So what are safety rules? This is really where, and this is the core of what they're trying to do. They're trying to establish absolute safety rules that show a generalization of what conduct should be. It has no relation to the real world. It has no relation to a legal standard. It has no relation to what happens in everyday life. So these are the typical type of reptile questions that you would see. Do you agree that chemical companies should never poison the neighboring residents? Now, these are the type of questions that are specifically designed so that a witness cannot say no. They have to agree to these types of questions. But as we all know, life is not in absolutes. There's a lot of maybes. There's a lot of sometimes, almost never, and always. So in responding to reptile theory as a whole, the overall theme has to be that absolute safety rules do not work in the real world. They're not legal standards, and you always have to take the conduct, you always have to take the questions and the presentation that plaintiff is making and bring it back into the actual circumstances and the facts in the particular matter. That's not what the plaintiffs want to do. The plaintiffs want to talk about you should never poison your neighbor. They don't want to talk about the fact that the company spent millions and millions of dollars to ensure that whatever was happening would not migrate from the site and impact the neighbor. Now, dealing specifically with the corporate designee at deposition, it's really a two-step process. One is the selection of the corporate representative, and two is the preparation of the witness. Now, the first one, I'm going to say, is almost more important than the second one. If you don't select the right witness, particularly with what you need to do to prepare for the type of questions that are going to be presented at a corporate representative deposition, all the prep in the world is not going to be successful. So who is the model corporate witness? One, smart, articulate, patient, smart. Now, that witness is going to play such a critical role in defending the reptile theory case. It's through this witness, whether it be at deposition or at trial, that the plaintiff is really going to try to establish the safety standards and the defendant's, the company's breach of those safety standards. The corporate witness carries a lot of weight. He's charged with being able to respond to the reptile theory in addition to all of the things that our corporate representatives have always needed to know. What is the theory of the case? What is the science? What are the facts? Those types of things. Witness preparation witness presentation can't emphasize this enough. What we're going to be asking the corporate designee to do is to spar with the plaintiff's counsel. That is not an easy thing. You need somebody who is got the right demeanor, is able to control themselves, use the right pace, have a sense of humility so that they can answer "I don't know" to a question that they don't know. An aggressive, confrontational, conceited corporate witness can be a disaster in a reptile theory case. So the corporate representative must understand the reptile theory. You have to take the time to explain what the plaintiff is trying to accomplish. He has to be familiar with the type of questions that are going to be presented. That means showing him depositions of these types of questions from that particular plaintiff's counsel, if you can find them, and if not, showing him examples from other matters. That's in addition to understanding what your overall themes are for the defense of the case, and of course the facts, the science, and the standards that are going to be applicable to the particular matter. Make no mistake about it, this is a credibility game. The jury is looking to blame someone for what happened, and if the corporate designee is not credible, then there's a significant likelihood that they're going to blame that particular defendant. You want a corporate designee who is going to be able to be genuine, to be consistent, and to appear believable. And in order to do that, they need to be consistent. They need to be able to respond to the variety of questions that they're going to get with the same even measure. You don't want them to engage in a fight with the plaintiff's counsel, but you want them to engage in semantics with the plaintiff's counsel in a way that is not confrontational, in a way that is not viewed as being arrogant. So let's talk specifically about the 3 rules for witness preparation for corporate designee and reptile theory cases. 1, the witness has to be prepared for a word war, essentially a game of semantics. Has to avoid that yes or no question. How do you say no if the question is, shouldn't a company never poison its neighbors? It's impossible to say no to that question if you're giving a yes or no response. And so they have to avoid yes or no responses. Now, this is completely different than what we are have traditionally told our witnesses. Answer the question presented, don't volunteer any more information, nothing more, nothing less. With reptile theory, we have to change that a little bit. We have to use the corporate representative as a subtle advocate for our position. I don't mean he has to be a lawyer on oral argument, but he has to be able to respond to the type of questions that he's going to be presented with. He has to recognize the reptile questions. And of course, skillful plaintiff's counsel will try to mix them in. They'll ask a whole bunch of yes or no questions that have nothing to do with reptile type questions, and then they'll slip in a reptile question. So the corporate designee needs to be prepared to be consistent. And that means not only fighting back on the reptile questions, but sometimes fighting back and not giving yes or no responses to other questions that are a little more benign, but still you don't want to seem like you're acting different to only the reptile questions. Rule number 2, never retreat and never surrender on safety rules. The whole goal of plaintiff's counsel is to set an unreasonable absolute safety rule that the jury, consciously or subconsciously, thinks is the law. You should never manufacture a harmful product. It sounds good, but we all know many products, most products are harmful if used incorrectly, whatever it may be. So these absolutes like never, always, must, those are the words that the corporate representative must be aware of and must be ready to deal with when they come up. Never agree to insufficient facts in a question. So what you want them to do is when the facts are not presented in the question, respond and say, well, I can't answer that question because you haven't told me A, B, or C. Again, and you want someone who's going to do that in a calm, consistent demeanor without getting confrontational. Because this is the type of scene where the plaintiff's counsel is going to want to be confrontational. You need somebody with a significant patience, more patience than I have, who's going to be ready to simply answer the questions in a very, very calm tone. This is what I mean by a response. I don't know what you mean by never poisoning neighbors, but a company should take reasonable steps to ensure conduct does not have a harmful impact on people in the area to the extent it can. Now, that's not answering the specific question. That's not giving a yes or no answer. It's taking the question, putting in the word reasonable, putting in circumstances. That way you blunt the effect of these reptile questions. Third rule is to always try to bring back the specifics of the situation and the company's conduct or behavior into the response to the reptile question. You can't go wrong by telling them exactly what it is the company did. Keep in mind, they're trying to set up a standard that has nothing to do with what the legal standard is and show that the company didn't live up to that incorrect standard, that absolute safety standard. By bringing back the actual conduct and the manner in which the company did act, you're blunting the effect of those questions. Here's an example. Company X reasonably believed that the filters it paid millions of dollars for on the refinery smokestack were removing all of the harmful chemicals from the smoke going out of the stack. This is the kind of response that you want your witness to give. Again, not in a confrontational way, because it's unlikely that your corporate witness, you don't want your corporate witness looking for the win against the plaintiff's lawyer. This isn't a battle of wits. What you're looking for is a tie. You're looking for making sure that the responses to the reptile questions are benign so that you can focus in on the actual conduct of your client, you can focus in on what the actual legal standards are, and you can focus in on what the actual damages are, because 9 times out of 10 when we're talking about these types of cases, we're talking about a case where the plaintiff doesn't want to talk about his client's real damages, doesn't want to talk about what really happened and what the real situation is, wants to change the focus to an absolute safety standard and then determine that the company did not live up to that absolute safety standard. So this is actually the closing phrase from that song, from the infamous Was Not Was, which is, everybody kill the dinosaur. And the word on the street is that this song may be performed by either a certain lawyer from Minnesota or a certain lawyer from Ohio on Saturday night. Thank you.